ask Gareth Prince to our class this morning. Prince is a trained lawyer. He's a South African lawyer and was the first to challenge the cannabis laws in South Africa at a tremendous personal cost to his career and family. As a Rastafari, he chose to obey his conscience and refused to apologize for a cannabis conviction. He argued that the laws against the herb were morally indefensible and unjust. And for this stance, he was declared not fit and proper to practice law in 1997 by the Cape Bar Association. And this led to the first challenge against South African cannabis laws, which was rejected in 2002 by the Constitutional Court of South Africa by a margin of 6-5, the closest margin in that court's history. And then Prince worked with the Center for Human Rights at the University of Pretoria to advance the case to the African Commission for Human Rights, People's Rights. And the commission held against him, and the case was then advanced to the Human Rights Committee at the United Nations, which also found against Prince. Now, in 2012, Prince was arrested again at his house for cultivating cannabis and charged with dealing and cultivation. This led to yet another constitutional challenge, and this resulted in the freedom of cannabis in South Africa, when in 2018, the Constitutional Court unanimously this time held that the laws prohibiting the usage of cannabis by adults in private spaces were unconstitutional. The South African government was then ordered by the court to create an enabling and legitimate environment for cannabis use and for the cannabis community. Prince has throughout this period persevered and put his legal training to good use by working with NGOs such as Lawyers for Human Rights and the Surplus People Project, whilst assisting and representing the Rastafari and members of the cannabis community at the Parliament of World Religions and the Consultative Conference of the Commission for the Promotion and Protection of Cultural, Religious, and Linguistic Rights of Communities. Currently, he serves as the National Chairperson of the Cannabis Development Council of South Africa, and he also works as a legal advisor. Prince, I would like to welcome you and meet my friends who are studying a module, Human Rights in Africa, and I'm really grateful that you could join us at such short notice. And I would like to yield the floor to you at this time. And we have the time to listen to your journey as you fought for this most important of rights, the right to freedom of religion. You are
there we are.
There we go. Perfect.
Okay. Thank you very much, Prof. And a warm African welcome to all of your students and everybody within the meeting. It is indeed an honor and a privilege to be speaking to you and addressing you on this very sensitive and personal journey that I've had thus far. So when it all started 27 years ago, I simply wanted to work. I had just finished my degrees, I'd finished my practicals, and I was eager to start working as an attorney within South Africa. Ironically, my first confrontation with the law was I was denied entrance into the profession because my legal degree didn't have Latin. Of all languages, it's like in South Africa, I was denied access to the profession because I didn't have Latin. And the law at the time allowed us to complete our degrees without Latin as such. And I had to go through another battle in order to convince the Minister of Justice to delete Latin from our curricula, which I was successful in, but meant that I couldn't take up the job that I had at the time. So when I applied again in 1997, I mentioned the fact that I had 2 previous convictions for possession of cannabis. And coming into the profession, I was between this choice: do I lie about this and conceal it, or do I open it? And I decided to be truthful and to reveal the fact that I had a criminal conviction. Now, in our law, if you had criminal convictions, then basically that barred you from entering the legal profession. However, I argued that in our country that we have professionals that had convictions for drinking and driving, attorneys, and they were allowed entrance into the profession. Now, the Law Society's answer to that was that, well, they apologized about their crimes, and they showed remorse. Here, Mr. Prince refused to admit that he was committing a crime, and he boldly said that he was going to continue to break the law. And that, in the minds of the Cape Legal Society or Law Society, was that, well, that makes you not fit and proper to practice as an attorney, because the duty of an attorney is to engender respect for the law in citizens. Here you had a legal professional that was boldly saying, I'm going to break the law and I'm not sorry about it. I argued that at the time that, that my case to a large extent was similar to that of Nelson Mandela when the Transvaal Law Society sought to remove him from the role of attorneys in 1954. Now, in 1954, Nelson Mandela, as part of the ANC, they were advocating for the abolition of past laws. And as a matter of fact, the ANC actually argued that we could use violence in order to get rid of these laws. But the High Court at the time argued that no, Mr. Mandela should not be removed from the role of attorneys because his political beliefs did not affect his ability to practice as a legal professional. And I felt that the same standard should have been used in my case. The fact that I practice my religion or my culture at home should not have a bearing on my ability to practice as an attorney, because I'm a professional and I'm able to separate my cultural or my religious beliefs from my legal obligations as such. And I also argued that based on the South African Constitution, which was newly adopted at the time, that my right to cultural and religious freedom should have allowed me or should have protected me or my cannabis usage, and that my usage of cannabis must not have been seen as criminal, but rather as cultural. So, but bearing in mind that we were a young democracy at the time, the thinking was that we could not launch a frontal challenge against the cannabis laws at the time. So we felt that the more pragmatic approach would have been to argue that my right to work, my right to freely choose my profession would have been the angle that we approached court with. And we argued that on the basis that as a Rastafari, there should have been an exemption for the Rastafari community from the provisions of the law on the basis of culture and religion. So that was the angle that we had at the time. Now, with legal practicalities, my counsel at the time submitted to the court that, and that was without me sanctioning it. He went and he submitted papers to court saying that Mr. Prince accepts that cannabis is a dependence producing substance. However, he argues that an exemption should be made for the Rastafari people. And when I saw that, I told counsel, but I never instructed you to say that. If you make that concession, that basically shoots us in the foot, because if we concede that cannabis does harm to society, then why should Rastafarians be exempted? What is it about them that would exempt them from this harm? And that's exactly the question that the Constitutional Court ultimately latched on, as well as the Supreme Court of Appeals, as well as the High Court. If there's an acknowledgement that the substance is harmful, then it's harmful for everybody, and not just those who are not Rastafari. And there's nothing about Rastafari's usage that would guarantee them not getting this harm, which completely missed the point in our respectful point of view. So as we well know that the Cape High Court, the Supreme Court of Appeals, as well as the Constitutional Court found against the Rastafari community, and the ratio decidendi of the court ultimately centered around the fact that government has a duty to protect its citizens, especially the young and the vulnerable. And because cannabis was seen as a dangerous dependence producing drug, the rights of the Rastafari community could be sacrificed in order to protect the health of the general society. Now, because the margin of the court was so close, 6-5, we thought, but well, it would be worthwhile to try and pursue this matter at the African Court for Human Rights and People's Duties. And I was very fortunate at the time to have collaborated with the Center for Human Rights at the University of Pretoria. And coincidentally, Professor Toko, as well as Professor Madlingosi, they were the ones that were instrumental in preparing the case to be brought to the African Court. That was in Gambia, Banjul, at the time. And it took us a couple of years to get there, because the South African government, they tried to raise procedural objections to us coming to the commission as such, and that in itself delayed the process for quite some time. But eventually we got to the court, and I must say that was one of the most frustrating and disappointing ventures and experiences within my life, because I came to establish, not that I went there naive and ignorant, but I came to found that the African Union is a paper tiger. At the end of the day, that they only existed in form, but however it had absolutely no power and no bite. So we do understand that South Africa's constitutional court at the time was considered the most advanced, the most well-run, the most organized within Africa as such. And here you had a situation where a high court, an appeals court, and the ultimate appeals court, the constitutional court, found against citizens. What hope was there that an African supranational body was going to find against these instruments that was considered to be the highest in Africa? However, the actual purpose of a body such as the African Court for Human Rights and People's Duties is to exercise that oversight over the highest courts within countries. And although we understand that the principles of subsidiarity and all of these other principles on which these international bodies lean on is such that you can't just willy-nilly replace a judgment from a national court with that of an oversight body such as the African Commission. On this particular point, one felt that, and also because there was such a significant minority, 5 judges of the court as against 6, it was important to investigate why 5 judges felt that there was no constitutional violation. And at the commission, very, very little attention was paid to that. In terms of the workings or the construction of the commission in itself, I was quite surprised that there was only one legal professional, one professor. His origin eludes me at this stage, but he wasn't even present at the sitting that we had in Banjul. And we find that the people there, they were basically administrators in their respective countries. None of them were lawyers, practicing advocates as such. And one felt that really the commission was poorly capacitated. I remember one commissioner from Malawi asking me at the time, telling me, this mbanji, this ganja, this cannabis, it causes people to go mad in my country. Why should we allow you to do this? And I'm sitting there and I'm telling you about, I'm sitting here, I've got 3 legal degrees. I'm reasoning in an intelligent, reasonable manner here with you. You can't think that I'm mad. And I've been using this for 25 years. So just these negative lies that were in the minds of these people, and the fact that they saw this as science was really disappointing at the time. And one could see that there was no real willpower to deal with these issues, because quite frankly, if your economic policies, if the outlook thereof is such that you primarily depend upon aid from the West, then you are not going to advance policies that would be against the interests of the West, or which would be against what the previous colonial masters require of those of us in Africa. And you find that really within South Africa, even at the time, we were but a democracy for 3-4 years at the time. And part of our economic policy was to rely heavily upon aid from the West. So what we were asking for, in essence, was a policy on cannabis that was much more advanced than what was happening in the West at the time. And that was never going to happen. Ultimately, at the African Commission, and I was so disappointed, because the commissioner that was charged with writing the report for the commission was Zimbabwe's one at the time. And and it's just like, that was just at the time, I think, when Zim started with that whole land expropriation process of them, and they themselves were very much in the world news. I mean, being bombarded by the people of the West, and I just knew I was not going to get a fair result from this commission. Quite ironically, during the break, I remember I saw him stand outside smoking a cigarette. And I told him, actually, that's the drug right there. That is the substance that you should be fighting against. But here you standing, I'm like smoking a cigarette. How are you going to judge me impartially? That was just a private conversation that we had during the break as such. But I definitely knew that I was not going to get the justice that I needed at this commission. Just the fact that, the manner in which they carried themselves during the session that I had, where myself and Professor Franz Viljoen were making our oral representations. One could see really that they didn't want to be in the room. I managed to speak to one of the aides of the commissioners afterwards, and she was telling me, this one lady was constantly asking, when are we ending? Because I need to go do shopping. Here, an individual was from a country that was down-pressed for years. Somebody or a part of a group or a community that faced jail for engaging in something that their ancestors have been accustomed with for hundreds of years. But still, they couldn't see the seriousness of that, because, quite frankly, none of them faced the kind of threat that us as the Rastafari people faced at the time. And really, for judges not to be able to put themselves in the shoes of those in front of them, that really leads to a disconnect. And that is a disconnect that people all over Africa, and for that matter, people all over the world, have felt, because judges do not really represent the interest of the poor. So as we then came to expect, that the commission placed entirely too much reliance on the principle of deference. And although they said that they couldn't agree with the contention of South Africa, which in essence argued for a hands-off approach by the commission, in the sense that trying to say that the commission wouldn't have the authority to supplant their decision, which could never be right. And the commission, acknowledged that in their communication, saying that, well, they would have the power to challenge that particular judgment as such, which technically speaking was correct, because that is the reason why the African Commission exists, to exist as an oversight over these particular matters. And the issue at hand was one that was very topical for the people of Africa, because you would remember that my initial approach to the court was based on the principle of equality. Even when I went before the Cape High Court, I argued that the laws against cannabis are morally indefensible and legally unjust. Because you cannot have a situation where people who are engaged in the same normative activity as us, which is what the tobacco and the alcohol community represent. Their activity is normatively speaking not different from ours. However, because these are the practices of our former colonial slave masters, these practices were very finely ingrained in the basic fabric of our society. You find that their cultural and religious practices were has been ingrained into our daily existence, and it lubricated the wheels of South African commerce as such. So those were not being questioned. However, ours were. And I was so disappointed at the time, because in 1998, just before my court case, the National Coalition for Gay and Lesbians, they managed to get a victory within South Africa. And the court held that even though the majority of the people might not agree with what gays and lesbians do, they deserve their right to existence within South Africa, because what they do is in essence a personal thing. And although people might have moral justifications for why they don't agree with them, that doesn't mean that gays and lesbians do not have the right to existence. And I felt that by extension, the same reasoning should have applied to the Rastafari people. But then again, in that judgment, the court held that one of the reasons that led them to grant gays and lesbians their rights is because that action would not have had an impact on the fiscus of our country. And that, in essence, was the concern around cannabis, because allowing cannabis at the time would have had disastrous consequences. Well, not objectively speaking for the fiscus, it would have had disastrous consequences for those within the tobacco, the alcohol, and the pharmaceutical fields, because these were the ones that stood to be challenged by the freedom of cannabis and by allowing cannabis to become part of the economic reality of our country. So the whole idea of a constitutional democracy is to grounded the idea that ours is society where right supposedly reigns over might. But I must say, quite frankly, that is something that just exists on paper, because the reality of our times still shows that we live in a society where those with economic might rule over right. And that's the fact that this constitutional democracy of South Africa is so highly elevated and respected within the world means very little for the indigenous people of South Africa. I'm well reminded of a professor that came and visited us in 1994 from Canada. Professor Carter Asmal invited him. And this guy told us that this constitution that you are about to adopt is going to mean very little for the people on the ground. It's going to provide an opportunity for some multinational companies and for rich people to approach the court, and it's going to make money for some senior counsel, some soaks that are going to argue these matters before court. But for the people on the ground, this constitution is not going to mean a lot. Now, with us youngsters at the time, we just felt, I'm like, yo, this guy just want to rein in on our parade, and like we are going to affect the changes as such. But with retrospect, man, that Canadian professor was spot on. 20 odd years later, and we find that the majority of the people are still struggling, and the very issues that I grappled with 24 years ago are still the issues that we are grappling with right here and now. So after the African Commission, they made that finding. We then advanced the matter to the United Nations Human Rights Commission. And we went there about 72 years after Haile Selassie, Rastafari, stood at the League of Nations. He was there in 1935, at the time when Italy invaded Ethiopia. And in that regard, you find that the League of Nations, instead of sanctioning Italy, they decided to sacrifice Rastafari on the altar of expediency. And rather, instead of vindicating the foundational principle of the League, which was that of collective security, they decided to go with a policy of appeasement. They thought that appeasing Italy would get Italy to side with them, the Allies, against Adolf Hitler. But as history tells us, Benito Mussolini sided with Adolf Hitler, and the result was the Second World War. 72 years later, Rastafari again stood before the League of Nations, and they again gave us the thumbs down. And the consequence, I mean, you would see that in the international picture, in 2008, the international economic crisis hit the United States. 1 year after they gave Rastafari the thumbs down. In 1906, when they gave us the thumbs down, the result was the Second World War. So you find that the injustice perpetrated against Rastafari is something that has international ramifications. As such, no, but because people are kept in tunnel vision, they seldomly see the bigger picture as such. You say, and it's really frustrating, bearing in mind that, and it would seem that those in the West simply want us to see law and justice through the lenses of the Europeans, whereas we as African people refuse to do that, because we had a sense of justice, we had a sense of equality long before the colonial advent. You understand? And we want an opportunity to develop those again within these times. There's no need for us to see our existence through the lens of Europe, because we can quite clearly see ourselves what it is that we want and what it is that we need to use in order to get it. Bodies such as the African Commission for Human Rights and People Duties, they have to perform a very important oversight duty within Africa. But these commissions are not capacitated, and they are not capacitated enough by the legal minds that we are going to need in order to challenge these conceptions that try to downpress us still on an international level. We still have these international treaties that want to dictate the path that its members take. If we take the issue of cannabis, in the international treaties, the 1961 as well as the 1998 one, you find that there's a provision that says if a country has a history of legitimate cannabis usage, in other words, a tradition, a cultural tradition of using cannabis, then they are, in a sense, exempted from the stringent provisions that the treaties dictate. Now, South Africa is one of the few countries that can actually claim a history of traditional licit usage of cannabis, because it's been part of our people's culture for nearly 1,000 years, right? So there's nothing that prevents the South African government from adopting a progressive attitude towards cannabis. There's nothing that dictates that the criminal penal code must be used in the administering of cannabis regulations. The fact that they chose to use a criminal penal sanction was a very deliberate decision. And we all know that the purpose of that was to suppress the indigenous aspiration, as well as the indigenous ability to develop an economy. Now we must understand that really the cannabis industry is a multi-billion rand industry, and it stands to be a major disruptive force towards Western economies. And we should be given the opportunity to give these countries a run for their money. The Germans claim to make the best beer in the world, but we can contest that claim because the cannabis community has never been given an opportunity to give them a run for their monies. You understand? We want the cannabis to be able to compete equally with other substances within this world. And we want to give people an opportunity for them to decide, but I'd rather choose cannabis as opposed to cigarettes or as opposed to alcohol. People must have the freedom to do that. Africa must be free to compete with the rest of the world. So therefore, because we live in a time where reason has to triumph over force, the institutions of law are very, very important within our society. Animals fight to resolve things amongst themselves. Human beings reason. And for that matter, the importance that we attach to courts is not misplaced. It is indeed how it should be. 5,000 years ago, even Socrates, he acknowledged that even though the finding against him was wrong, he encouraged his people not to fight it, because what do we become? I mean, like, if we don't succumb to reason, then we are no better than the animals. And we have to accept that law, equality, and justice must guide us going forward. And it's very important that when it comes to law and justice, that we exercise our judgments impartially. And that's what the contextual approach is what must inform society. And in reading this thing, I'm well reminded of the fact that Germany, ironically, was one of the first countries to pen what I would call a modestly jurisprudentially sound judgment in the Bundesverfassungsgericht of 1994. There was a cannabis decision that centered around the issues of proportionality. Now, when reading this judgment, you know, I'm like, I was quite impressed until I arrived at paragraph 197. Now, in that particular court case, the court argued that cannabis cannot be equated with alcohol and tobacco. Now, if you go to the judgment and you read the reasons why the judge said it cannot be equated, it's laughable. But the fact that that is what was passed as science at the time, you know, meant that the judges could argue that no, nicotine is not a drug, but cannabis is. The judge argued that there's no other products that one can make from cannabis, and the reason why people use cannabis is simply to get high. At least with alcohol, you find that it had medicinal applications. When it came to tobacco, you find that German culture, to a large extent, it allowed tobacco. But because Germany didn't know cannabis, that's why it was totally foreign to them. And that's why German society need not see cannabis in the same way that they see alcohol and tobacco. Now, for Germany, that could have been sound. But the very same reasoning, if you were to apply it in South Africa, then that is actually the justification for why cannabis should be allowed and not alcohol and tobacco, because both of those substances are foreign to us. But legal people can't that, because that was just racist, what he said in that particular judgment. You know, but we know in 1993 was just before, I think that was just before we had that whole, Hollywood made a movie about that, Insider, where this tobacco guy spilled the whole beans on what was happening in the tobacco industry. But that judgment was before then. That's why this judge could say nicotine is not a drug, and that nicotine doesn't have the disastrous effects that supposedly cannabis has. You understand? And the overt racism expressed in paragraph 197 of that judgment is in essence what informed South African society when they deliberated during those early days on this particular matter, because they were seeing it through the perspectives of Western commerce and not through the perspective of cultural and religious freedom within South Africa. So in the 2012, when I was arrested again for cultivating cannabis at my house, look, the initial judgment didn't allow us to have anything. I mean, like, it was just cannabis is illegal as such now. And I tried to cultivate it at my house because I couldn't buy it on the streets. But then I was told that even that is not acceptable. So we challenged it on the basis of, this time we were saying that, no, we don't want an exemption. We're saying that any adult South African should have the right to cultivate his cannabis for several reasons. The court decided to grant the application on the basis of privacy, which I felt was a cop-out, but because judicial minimalism is the judicial philosophy of the South African Constitutional Court, and that basically dictates that when courts give judgment, they only have to develop one particular right. There's another part of our jurisprudence says that if several rights are mentioned in an application, the court only have to develop jurisprudentially one, but they have to pronounce on the others. In this particular instance, they said that they couldn't pronounce on the right to equality because the right to equality wasn't fully developed in the papers, which was another cop-out on the part of the court, because the law only requires an applicant to make out a prima facie case when it comes to constitutional complaints. Once a prima facie case is made out, then the onus shifts onto the state to prove why the limitation is justifiable. Now, we argued that an arrest by any standard is prima facie limitation of a right. And we argued that the sanction of arrest is totally unfair in relation to cannabis, especially if we bear in mind that those who find themselves in the same normative position as us do not face the threat of arrest. So the court ultimately decided that people should be able to use it in privacy. However, the contradiction was that the court didn't mention about where you are going to source your cannabis. The court didn't mention about what about those who are not in a position to grow? What about those who don't have sorry for that. What about those who don't have homes? The court didn't think, or they didn't specify that in their judgment, which is in a sense understandable, because our constitutional court have been wrapped over the fingers in the past for being too bold in their judgment and for stepping into the path of the legislature and the executive, right? Whereas the separation of powers doctrine dictate that they shouldn't be doing that. They should give each other space to perform their work as such. So one can understand why the constitutional court to some extent was reluctant to be too broad in their judgment, seeing that it would now be the task of the legislature to develop inclusive constitutional laws for cannabis going forward. But the point that I'm making is that ultimately for us, this was an equality issue. Cannabis should be allowed the same competitive space as other substances. We're not making any claims in this regard. We're just saying, at the very least, equality dictates that the cannabis community should not be treated worse than the alcohol and or the tobacco community. And that ultimately, that is the thing that the legislature would have to get in place. And ultimately, we felt that these should have been the issues that should have been canvassed more jurisprudentially at the African Court for Human Rights and People's Duties, even in our courts, as well as at the United Nations Human Rights Committee. We need to understand, and we need to capacitate these bodies for them to have a real impact on Africa going forward. You know, we really, as the world, we do live in a time where reason has to triumph over force, and it is indeed imperative that we do not bow to short-sighted interest, but really understand that as a world we are one, and that as a world we have to ensure that we adopt safe economic and environmental practices, and that we do not seek progress at the cost of our environment, that we do not seek progress at the cost of some communities, but that we live and let live as a people. You know, in order for bodies such as the African Commission on Human Rights and People's Duties to become more effective, we must ensure that the commissioners there are legally trained, legally sound, and that they are able to advance the development of the human rights culture in a manner that is progressive, in a manner that is pro-African, in a manner that seeks to advance our interest, and not our interest as seen through the West, not as interest that's going to ensure that the West enjoy their comfortable position and that we remain simply providers of raw materials to them. And if that is not the case, then we find that these institutions are going to remain paper tigers, and you find that but they will not serve the interest of the larger African community. And within Africa, there's a dire need for us to do that. And it's really sad that institutions such as these that they do not realize the power that they have. Prof, I don't know how we're doing for time at this stage.
We are good for time. I mean, do you have any additional remarks? Do you want to, address some of the developments after the constitutional court's, decision allowing, personal use? What has happened in the legal frameworks after that?
Yes, I think that this would be a good time. Yes. So you'd know that the Constitutional Court gave Parliament 24 months to remedy the defects in the law. So there's certain sections within the Drugs and Drug Trafficking Act, as well as the Medicines and Related Substance Act, would have to be changed in order to accommodate cannabis. So the 24 months passed. 18 of those months passed before COVID hit. And in that 18 months, you find that very, very little public consultations had been done on the part of government. And a sad thing is that even though the notion of public participation is a foundational principle of a constitutional democracy, we find that the South African government has reneged on that principle in regard to several pieces of legislation, and they've been taken to the court several times because they wanted to pass legislation that didn't adhere to the principle of adequate public participation. Unfortunately, you have a situation again where they are trying to develop a law from the top down, whereas we argue that this law must be informed from the bottom up. You need to consult with grassroots communities. You need to ask these people and not dictate to them what it is that they should want or what it is that they need policy. And that hasn't happened. We had the first meeting with government as civil society online, and that was about five weeks ago, for the first time in about 28 months. There was absolutely no public participation in the development of the Cannabis for Private Purposes bill. Whereas we argue that we are in a position to develop an holistic bill that would simultaneously give effect to the rights that were mentioned in our application, right? It would seem that the thinking of the government is that justice simply have to provide a bill that accommodates private usage. But the criticisms against that was, where are people going to source seed from? Why is it that this bill doesn't speak to any commercial activity around the plant? Why is it that the bill still proposes to send people to jail for up to 15 years for simply cultivating plants? So we argue that the bill was fundamentally, or the current bill is fundamentally flawed, and it is not going to pass constitutional muster, primarily because it still sees the issue of cannabis as an issue for the criminal justice system, as an issue for the penal code. Whereas we are saying this is something that should be removed entirely from the penal code, because the issue of cannabis, or the issue of substances for that matter, is an issue for social development and not an issue for the criminal justice system. Even if it is that you accept that an addict is not a criminal, at best is a patient or a victim, And you don't throw a patient in jail, you give them medicine. So we're saying that that constitutional jurisprudence demand that if you have a problem, then you must try and resolve that problem in a manner that does the least impact on fundamental human rights. So if we are able to address or redress the problem of substance use and abuse by not arresting people, then that is the avenue that we should pursue. That is what an enlightened constitutional democracy dictates. So we find ourselves in a position now, 30 months after the Constitutional Court judgment. And the reality of our situation is that the members of our community still get arrested. The Constitutional Court placed the discretion in the hands of the police. Now, that for me was a negligible decision, because the uncontested evidence before the court that came from an NGO here in Cape Town, they provided an affidavit, a criminal justice NGO here in Cape Town, the University of Cape Town's Criminology Department. They proved that the police are complicit in the human rights violations against the cannabis community. Yet the Constitutional Court placed the discretion to decide whether a person should be arrested or not for cultivation of cannabis in the hands of ill-trained police officers. Officers that has been proven to be complicit in human rights violations against the cannabis community. So the reality is that our members still get harassed, they still get arrested, even though the Constitutional Court said adult citizens are free to cultivate their own cannabis plants. So the proposed bill says that an adult household could have 8 plants. So if the police comes to your house and they see 80 plants, then it is within the rights of the police to conclude that this is not for private usage and that this is cultivation, and that therefore you should still be arrested. Now, that to my mind is just a contradiction in terms. A very basic principle of criminal law says that you are innocent until you are proven guilty. And in any criminal prosecution, your guilt must be established beyond a reasonable doubt. Now, as it stands, you've got a Constitutional Court judgment that says the laws against cannabis are unconstitutional. It's up to Parliament to come forth with laws that then pass the constitutional test. So that means that in the period until this law is established, there is a doubt with regard to the crime of cannabis dealing or not. And that doubt should always be exercised in favor of freedom. So whenever the police, in actual fact, finds themselves with this discretion, whether they should arrest or not, that discretion must be exercised in favor of freedom and not in favor of bringing a so-called criminal to book. And to that extent, you'd find that that principle in itself was established in one of the very first criminal law cases that the Constitutional Court dealt with. Our Professor Albie Sachs, who was one of the first Constitutional Court judges, he actually said in a separate concurring judgment in State versus Coetzee, that is a 1995 Constitutional Court decision, and in paragraph 220 of that decision, he actually says, whenever we have to decide, on the one hand, do we assist the state to bring a criminal to book, or on the other hand, do we advance fundamental human rights? And Judge Albie Sachs said it's a no-brainer. You always advance fundamental human rights, because that is the very fundamental premise of a constitutional democracy. You might be familiar with the Blackstone principle that says we would rather let 9 or 10 guilty people go free than to let one innocent person suffer. That is the reason why there is such a high level of proof required in any criminal proceeding, and it should rightfully be high. And we are saying that that does not exist in relation to cannabis. So we told our government, we have an opportunity to use the development of this new cannabis law in order and really to establish a new social compact between government and its people. We have the ability to develop a legislative blueprint that could be the envy of the rest of the world if we really abide by the fundamental principles of our constitution. That is all that we are asking. We're not asking for special treatment as the cannabis community. We are asking for equal treatment. And the notion of equality is something that is very, very near and dear to South African citizens. There's a fundamental reason why equality is the first mentioned right in our constitution. And that is because of the history of this country, where we were denied fundamental human rights on the basis of who we are, immutable characteristics. Right? Our humanity was denied right up until 1960. Professor Sachs tells us in his book, Justice in South Africa. It was still accepted in legal circles by highly acclaimed jurists that South Africa was res nullius. That means that we belong to the land. And because the colonial slave master discovered or conquered the land, that meant he got us with the land. You know, that notion that denied the humanity of African people, the sameness of African people to those of European descent. You understand? Right up until the 1960s, that was a prevalent thought in the legal community. Now, to think that that type of thinking would simply be undone over 30, 40 years is naive. And they've just managed to disguise it much better in this day and age. You understand? But we are not to be deterred by that. And we still feel that we are going to develop, especially if you've got anything to do about it, we are going to develop a new law that's going to be progressive and that's going to be a trendsetter and that is going to serve ultimately the South African society, because we believe that cannabis provides us with the most viable opportunity to strengthen ourselves economically and to deal with some of the domestic problems that we face within South Africa, especially a lack of food, clothes, shelter, health, education, and welfare. And we feel that cannabis has a very important part to play in the restoration of the South African and the African dignity. That is in essence what we are saying. It's about dignity, and it's about assuring that African people have a sustainable, viable way of going forward. We want to work with the plant in order to advance ourselves economically, spiritually, physically, physiologically, as such. And we feel that the cannabis industry is one of the few environmentally friendly, sustainable, as well as something that will allow us to compete with the West, because we've got several things that plays to our advantage. And as Rastafari people, one of our guiding principles is that you need to use what you have in order to get what you want. In this particular instance, we've got cannabis. We've got a very good we've got very good environmental conditions in order for the plant to prosper and flourish. And that is what we must use, and use that in order to provide within the needs of our people and to make us an economic powerhouse that can compete with the rest of the world. But we need to have proper legislative and regulatory frameworks in place. And these legislative and regulatory frameworks mustn't be designed to keep out the small player. It has to be on a different paradigm than what is currently being done. Because the capitalism, we don't want cannabis simply to be assimilated into the current economic mold, but we need to develop a different mold, one that is based on sharing and caring and not just on exploitation. And we feel that with cannabis, we are able to do that if our legislators get out of their own way, if they get out of the plant's way, and they allow the people to demonstrate what it is that they can do if they get the proper assistance.
All right, thank you. Thank you so much. And yeah, I would like now to open the floor to questions from members of the class. Guys, short, sharp questions, please. Yes, no? Okay, I'll start us off whilst folks. Oh, Naveen, go
Yeah, I
ahead.
just have a kind of a general question, but I just wanted to ask, where do you think the line should be drawn when it comes to for allowing for, I would say, an exception in the name of religion? I don't know if my question is clear.
In relation, okay. Ras, you heard the question?
Yes, I did. She was asking like where the line should be drawn. Is it aimed at asking like what kind of, I mean, like what would be an example of an exception?
Except as your case, for example, like in the use of cannabis, for example, in the name of religion, how do you, for other, I don't have other examples, but I just wanted to ask, what do you think the line is drawn for making such exceptions? So,
I'm with you. I'm with you. For instance, I always thought about like, what about those who say that, listen, I'm a Satanist and I need to drink blood, so I need to sacrifice cats and dogs in order to practice that. Now, for me, the line would always have been if you say that if your religious practice is going to have an impact on other forms of life, then I believe, generally speaking, we would be able to ask questions, right? We should be able to ask questions in that regard. So if it has a negative impact, the ability of others to live their lives or to exercise their rights, then I believe that it could legitimately be questions. We felt that because of what we're doing, even in relation to children, we're saying that it doesn't count in that regard, because you do not have the same provisions when it comes to alcohol and tobacco. People smoke tobacco in their houses, and secondary smoke is much more dangerous to a person that doesn't smoke. But people do not get incarcerated for doing that as such. But I always felt that there should be there can be situations where we would be able to limit the practice in your religion, especially if it have a damaging effect on the ability of others to live their lives or to enjoy their rights.
Thank you.
Good. Any follow-up questions? Yes, Abby, go ahead.
Okay, thank you. I just wanted to ask what happened to your professional career after this altercation came up? Because before you were not allowed to practice your law, but after the grant of the cannabis usage in private spaces, what eventually happened? What developed in your career?
I have not been. I still have ambition to be admitted as an advocate in my country. The Law Society haven't reached out to me. None of them have. They've never showed any interest, and I've always argued that my usage of cannabis should not have had an impact on my ability to practice as an attorney. But the legal profession is still a very, very conservative one, and it's still a very, very close-knit one. And even within the profession, African, Black, and Brown people, there are very few that's willing to challenge the conventions of the legal profession. So at the moment, I'm still not admitted as an attorney as such, not because, quite frankly, they wouldn't have a principled objection to allowing me at this stage. However, I wanna, when I admit myself or have myself admitted as an advocate, I want to know at the end of the day that I'm free as I want to be, and that the conditions for that doesn't exist as of yet. So we're in the process of ensuring that we have a constitutionally compliant law that would really respect the dignity of members of the cannabis community as such. Because the reality was that for the past 25 years, the Rastafari community has been pictured as a criminal community instead of a cultural community. And instead of being seen as a cultural activist, I was seen as a criminal, somebody that is not fit and proper to practice law.
Naveen? Yes?
Yeah, I'm sorry, this is kind of a personal question, but I wanted to ask if you have any regret that honestly disclosing being member of the cannabis community? Because it's
No, I don't.
affecting. Okay, good.
Never,
Okay.
never. Like, because for me, that's just, that was my battle. I mean, like, you had Nelson Mandela, you had Gandhi, all of these people, that actually, and their reasoning was that when injustice becomes law, then resistance becomes duty. You see, and for me, there was no other principle, and I've always seen myself as privileged and as honored, for being the one that could lead the struggle in this regard, and if I were to get a chance to do it over, I'd do it again.
Yeah, I remember. It's incredible that this was almost 20 years ago, when we were talking about taking a roll call of secret users of the herb in the Cape Bar, in 2002. Say, okay, so let's see who amongst these hasn't used, and all of that. But I would like to link back to this question of disclosure and that, and the fact that your eventual victory comes through the elaboration of property rights. I mean, what is your view about this being the anchor which allows use for religious worship, and that would it have been better vindication, if I may use that phrase, if this was based on the right to religion explicitly, or your freedom to choose your employment and all of that, rather than the right to privacy?
Prof, I argue that from the very start, that the angle of religious and cultural rights was chosen as a matter of pragmatism, right? I was conscious of the fact that, being a young democracy, a frontal challenge to the constitutionality of the cannabis laws was highly unlikely to succeed at that particular time. So we felt that approaching it on the basis of religious and cultural freedom was something that South Africans could much readily identify with at the time. So as to say, listen, seeing that we've just granted gays and lesbians something that the majority of South Africans, it doesn't matter from what religion you come from, were against, the fact that we allowed these people the freedom to live their lives meant that a small community like the Rastafari community could also be given the right to live their lives. But the matter should have been approached on the basis of equality. Yes. In our country, in our Equality Act, Section 14(2)(c), there's a provision that asks, does the provision in question, like the one that's being challenged now, does it reasonably and justifiably differentiate between groups of people on the basis of objective criteria that is related to the intrinsic nature of the activity concerned? Now, if you evaluate the cannabis as against that standard, then quite clearly the law differentiates between groups of people. People in the cannabis community faces prison, whereas people in the tobacco and alcohol community doesn't. So what are the criteria that the law uses to discriminate between these groups of people? And you find that these criteria are not objective. They are not scientific. They are not reasonable. They're not justifiable. It's based in politics. Simply that. There's no scientific justification for differentiating between cannabis, cigarettes, and alcohol. So we're saying that equality before the law, at the very least, demand that I not be treated worse. Personally, I'm saying there's no comparison between alcohol, tobacco, and cannabis, because the previous two are mass murderers, and there's no objective scientific evidence of the fact that cannabis take lives. There's no medicinal application to tobacco. People use it simply for leisure and recreation, even though it kills millions of people worldwide. There's no government in the world that would dare to make a law against tobacco. There's no politician that would campaign on that basis, because they know they'll be shooting themselves in the foot. So the court choosing privacy was simply the manner in which government could save face. That allowed them not to open the can of worms that would have been equality, but rather privacy is something that they could use in order to justify why this particular law is unconstitutional without leaving too much egg on government's face, ultimately. And then also it still limits us, because now it tells you you're free to grow it or you're free to go get it, but if you share it with your friend, then you're dealing. Even if you don't charge money for it, you just give it to them. That's dealing. And when you deal in cannabis, that's when you run the risk of being arrested and being jailed for many years, still in terms of this proposed bill for private purposes that they have now. It's a judgment that was very ill-conceived. The fact that it took them nearly 10 months to deliver this judgment was another disappointing aspect of this case, because you don't really see it as being a jurisprudential tour de force. You know, the reasoning of the court in the case was very uninspiring. They did very, to my mind, the High Court judgment in Cape Town was much more developed than the Constitutional Court judgment at the end. And we ask ourselves, why is it that, within South Africa, that at this point of time, the judges are so reluctant in this country, it would seem to upset the status quo. That is why the judiciary remains one of the least transformed institutions within our society. And Justice Moseneke, when he delivered the fourth Bram Fisher Memorial Lecture, he warned that instead of becoming the vanguard of our constitutional liberation, judges were in danger of being the main ones to prevent the transition to this freedom, because of their reluctance to embrace the spirit of our new constitution, and simply wanting to do things in the way that things were being done in the past, which was never going to be a practical manner to ensure that the notions or the principles of constitutionalism becomes embedded in the hearts and minds of South African citizens. One of the criticisms against the judicial policy of minimalism, right, which was the judicial philosophy that the court adopted, was it is not suited to a society like us. Judicial minimalism is something that could work in a place like Germany, because in Germany you find the majority of Germans are of one cultural tradition, right? And the manner in which they do things have developed over hundreds of years. Therefore, a court should not be quick to disturb that. So therefore, I can understand how a policy such as minimalism could be suited to Germany. It is not suited to South Africa, because we want judges to be proactive in this regard. We want judges to ensure that our understanding of equality and justice and dignity gets enhanced Because if it is seen through the European lenses, it is never going to speak towards the conditions of us on the ground.
Thank you. Thank you so much.
Therefore, I'm like, there has to be so instead of judicial minimalism, we need a heightened sense of judicial activism.
Mhm. Okay. All right, guys. Gareth Prince has been with us for over an hour, and I think we can say our thank yous. And yes, we are really grateful that you could join us today. Unless there's one pressing question, I think let's say thank you, and we shall hopefully see you soon. Mm-hmm.
Yeah, please feel free to call on us anytime.
Okay. All right. Thanks, Gary. Thank you. Thank you so much. And God bless.
Thanks so much for having me.
Thank you so much, Mr. Gareth. It's been a pleasure hearing you talk.
Okay.